The where we have discussed the duties of an agent, now we are going to discuss the rights of an agent. First right of an agent is to right to remuneration, section 219 and section 220. So, in case of non-gracious services, agent is entitled to receive the agreed remuneration. Means the remuneration which was decided in a contract between the agent and the principal. In case of non-gracious services, the agent has the right to receive that. Payment for the performance of any act is done not due to agent until the completion of such act. That means till the agent completes all the assigned tasks, he may not demand for the payment of the performance. This is being cleared in the case of Sheikh Farid Baksh versus Hargun Lal Singh. An agent was appointed to introduce a purchaser willing to purchase Mr. B's property. He did introduce one, and even the sale was settled. The earnest money paid out, but it could not be completed through the purchaser's inability to find money. The agent was, however, held entitled to his agreed commission. Second right of an agent is right of retainer. Agent can retain principal's money until his all claims in respect of the remuneration or in respect of advances made or in respect of any lawful expenses incurred by the agents are being paid. He can also exercise the right of the lien if any kind of goods of the principal are under the custody of the agent. Third right of an agent is a right of lien under section 221. Agent is entitled to retain goods, papers, or any kind of property of the principal until all the amount due to him is being paid. But yes, he cannot sell that. He only has the right of lien, but he don't have the right to sell. Next right of agent is right to be indemnified against consequences of lawful acts under section 222. If in the agency business the agent has caused some kind of losses, so all these losses are to be indemnified by the principal to the agent. But where the agent has incurred some kind of damages expenses in also in the defending action on behalf of the principal, he is also entitled for the reimbursement of all those damages and the expenses. But if the contract is illegal, it is important here to mention, if the expenses are being done for the illegal contract, the claim of the agent cannot be enforced. Let's see the example. Mr. B at Singapore, under instructions from Mr. A of Calcutta, contracts with Mr. C to deliver certain goods to him. Mr. A does not send the goods to Mr. B, and Mr. C sues Mr. B for the breach of contract. Mr. B informs Mr. A of the suit, and Mr. A authorizes him to defend the suit. Mr. B is compelled to pay damages of the suit, obviously, and here Mr. A is liable to pay for such damages and expenses to Mr. B. Next point is right to be indemnified against consequences of acts done in good faith, section 223. The agent of the principal has the right to be indemnified against all the consequences of all the acts which he has performed in the good faith. When the agent knows that the act was unlawful and even he works for that, and only in that case he cannot be indemnified, but otherwise in all other cases he has a right to be indemnified. Let's see the example. Mr. B, at the request of Mr. A, sells goods in the possession of Mr. A, but Mr. A had no right to dispose of. Mr. B does not know this and hand over the proceeds of the sales to Mr. A. Afterwards, Mr. C, true owner of the goods, sues Mr. B and recovers the value of goods and costs. Mr. A is liable to indemnify Mr. B for what he was compelled to pay to Mr. C and from Mr. B's own expenses. Right of indemnity does not extend also to the criminal acts, even though those criminal acts were authorized by the principal to the agent. Let's see the example. Mr. A employs Mr. B to beat Mr. C, which is totally a criminal act, and agrees to indemnify him against all the consequences of the act. Mr. B thereupon beats Mr. C and has to pay damages to Mr. C. But because it was a criminal act, now Mr. A is not liable to indemnify Mr. B for the damages what he had paid to Mr. C. Next right of the agent is the right to compensation according to section 225. Principal is liable to make compensation to the agent for any loss, for any injury caused to the agent because of the neglect or want of skill of the principal. See the example. Mr. A employs Mr. B as bricklayer in building a house and puts up the scaffolding himself. The scaffolding is unskillfully put up and Mr. B is in the consequence hurt. Now Mr. A is liable to make compensation to Mr. B.